Good afternoon, 307 here at Tampa Bay's Tan Talk Radio Network. It is the Legal Forum, and your calls are welcomed in here, 727-441-3000. That's 727-441-3000 or 1-866-826-1340. We're going to be talking about DUIs here today, and I don't know, I don't want to talk about our audience, but I'm sure some of them could use some advice on this subject. I'm kidding. Today we're going to be talking to CC Condi with the, excuse me here. Let me fix my machine here. What is the name of your law group again? I'm finding myself without my papers here.
Lucas, Green, and Magazine.
And how long have you been with them?
I've been with them almost 8 years. It'll be 8 years in January. I'm an associate attorney with that firm. Okay.
And it says here you got your bachelor's degree in political science in 1988 and your Juris Doctor in 1991 from Western New England College of Law.
That's true, but I also went to University of Miami undergrad, and I know there's a big game coming up tomorrow. So go Canes.
So you've been around. That's excellent.
I have.
So it says here that you are associate attorney at Lucas, Green, and Magazine. That's what I was looking for.
That's correct.
And you focus on criminal law?
I do. The firm, mostly the other attorneys do personal injury, medical malpractice, but I exclusively do criminal law and a little bit of civil, but mostly criminal law.
Okay. And let's see, it says you represent clients on all criminal allegations, including traffic DMV hearings, civil injunctions, contempt of court motions, and you've tried over 140 jury trials, including homicide, manslaughter, capital sexual battery, as well as other felony and misdemeanor charges.
That's true. I mean, I've tried everything, any crime that you can think of. I think I've gone to trial on it.
So have you been on both sides?
No, I was never a prosecutor.
Okay.
I started out as a legal intern in Miami-Dade County, and I did that for about a year, and then I started to work for the Public Defender's Office here in the Sixth Circuit for Pasco and Pinellas counties. But I was in Pasco County, so I have 12 and a half years with the Public Defender's Office, where I tried capital murder, death penalty cases, and like I said, every kind of serious allegation you can think of, and including, misdemeanors and DUIs and things of that nature.
Okay. And it says you've been with the Florida Bar since 1992?
Correct. I've been a licensed attorney, for 21 years.
And you're also a member of the West Pasco Bar Association.
I am.
The Clearwater Bar Association, the Florida Association of Criminal Defense Lawyers.
That's right, FACDL. Correct.
You've got all the qualifications.
I do. And I've been actively engaged in all those organizations for a number of years,
So let's get into the meat of this here.
Okay.
What can you be charged with a DUI for taking prescription painkillers? I know everybody knows, obviously alcohol, and there's other things that you can get in trouble for. But what about the prescription medication?
Unfortunately, you can. I mean, absolutely. I've gotten quite a few clients charged with DUI who've not had a drop of alcohol. It's based upon whether the person is impaired. So whether you're impaired by alcohol or you're impaired by your own prescription drugs, that is the standard that the officers are looking for to determine whether you're fit to drive the vehicle. So I have a lot of clients that come in and say, hey, I've got a prescription for these medications that were in my urine or in my blood, depending on how the police were able to ascertain what the person was on. And they say, why is that illegal? I mean, if the doctor prescribes it to me, I've been taking it for years, why am I getting a DUI? Again, it goes down to impairment. So if you are taking oxycodone, a lot of people take a lot of narcotics for some serious pain, and if they are impaired by that narcotic, then yes, they can get a DUI, even though it's a prescribed drug.
So if let's say person X has taken however many milligrams of oxycodone, and person Y has taken the same amount,
right?
One person could get the DUI and the other couldn't?
That's true, because some people may have developed a tolerance to it over a period of years. They've been taking it. They've been taking a certain dosage. And the way that you fight that DUI oftentimes is that you'd need a toxicologist to come in and testify for you. And, in order to convince a jury that you weren't impaired by these medications because of your unique circumstances and that you've been taking these medications for a while, There's certain facts that the toxicologist would need to have been presented for that toxicologist to make that opinion. But that's an expert witness. And unfortunately with DUIs, a lot of people don't have the kind of money that it takes to hire a toxicologist to come in and give that testimony because it's very expensive.
So essentially it's at the officer's discretion?
It is. I mean, there are what they call DRE expert officers. That's called drug recognition experts. And these officers are uniquely trained to determine whether someone's under the influence of drugs. And they will tell you, because I've had quite a number of cases where I've had to depose such DRE expert, and they will tell you that they can look at someone's eyes and someone's behavior, and they can actually tell what kind of drug, basically, that they've been taking.
Amazing.
Yeah, but not necessarily the amount. I mean, the amount would come from an actual blood test.
Right.
And some people refuse, some people, they, consent to it.
So specifically, the only way they'd be able to test on site would be alcohol.
Right. The alcohol, some of the officers used one of the handheld breath tests, so they would be able to determine, whether someone is over the limit just from the handheld, but not for drugs, no. Drugs, basically already under arrest for DUI by the time the officer will then, get either urine from you or get if let's say you were in an accident and the EMS showed up, they can get a blood draw from you there at the scene with the ambulance, or if you're in the hospital being treated, they can get a blood draw there. But the officer won't know the results of those tests, either the urine or the blood draw, until maybe months later or sometime later. And again, that's something that they would use to prove that you're under the influence, depending on what comes back in your urine or your blood.
Now, what if the officer pulls you over and smells marijuana, for example? What would be the procedure there? Could they say presume that you were under the influence because they smelled the odor?
Right. They could do what they call a DUI investigation based on the odor of marijuana. But again, they would have to look at the person. They would have to do the field sobriety test. They would have to conduct, all the examinations that the officers would utilize to determine whether that person was impaired by the marijuana. So odor alone is not enough, to arrest someone for DUI. But it gets the officers to the point where they can legally conduct an investigation of you to see whether you are impaired.
Okay. Can prior DUI convictions from other states be used against you?
Yes, they can. But it is the burden of the state attorney's office to find those prior convictions in order to use them against you. In essence, you have a right to remain. A person who is arrested has a right to remain silent. So they don't have to tell the officer or the state attorney, hey, I've got other DUIs in Massachusetts. I'm just saying Massachusetts, not to take anything away from Massachusetts people, but I just had a case recently where the client had a prior record from Massachusetts, and it was actually something that the state attorney ordered and got from the state of Massachusetts. So, yes, prior convictions can be used against you. However, an issue comes up whether the state attorney can actually prove those convictions. So, in essence, you may challenge the convictions, and then they have to prove that the convictions were indeed your convictions and not a mistake.
Okay, now, can I get a hardship license? Let's say that I get a DUI. Can I get a hardship license after I've been arrested?
You can, and now the DMV has a relatively new process by which you can get a hardship license. So the standard way to get a hardship license, if you were qualified to get a hardship, let's say it's a first-time DUI, you can challenge the suspension of your driver's license with the DMV. The procedure is called a formal review, and you have to file that within 10 days of your arrest, and you are challenging only certain legal aspects of the unlawful blood alcohol suspension or refusal suspension.
Okay.
So, and then in the meantime, the DMV will give you like a temporary license to drive on a hardship pending that formal review hearing. So if you do go through to the formal review hearing and you win that formal review hearing, you convince the hearing officer or your lawyer that your license should be reinstated, then you can get your license back, actually, regular license back.
About how long of a process would that be?
Well, the formal review, you have to file within 10 days, and then they have to set the hearing within, I think it's like 15 days. Don't quote me on that. But
okay.
It's a relatively short period of time, unless you waive, that 15-day time frame, and then it could be 30 days out or 45 days out. And a lot of individuals who have attorneys, the attorney will do that because of their scheduling problems. They'll want to be able to, clear their schedule to appear for the client's hearing. But DMV has something new where if you want to waive your formal review, your right to a formal review, and you just want to go straight to the hardship license, you have to complete DUI school, and you have to have a clean driving record. You can have no suspensions from any other issue, and it has to be your first DUI.
Okay.
So if you do that, and then you file a paperwork that the DMV has, which is a waiver of the formal review paper, then they will go ahead and grant you, if you do qualify, the hardship license. And you will drive on that hardship license for the remainder of the suspension period, which is 6 months for an unlawful blood alcohol level.
Okay. We're, just in case you just tuned in, this is The Legal Forum. We're talking today with CeCe Conde from the law firm of, I'm going to get this right one of these times, Lucas Green and Magazine. And she's been kind enough to come in and talk with us about DUIs. If you have any question, you can give us a call at 727-441-3000 or 1-866-826-1340, and that's nationwide. Now, everybody hears the old wives' tale, or whatever you want to call it. If I get pulled over, just tell them, no, I'm not going to take the test, and make them take you to the hospital and get the blood test or whatever.
Yeah.
Is that true? Are you required to perform a field sobriety test on site or the breath test?
Well, no. However, if the officer, based on whatever clues of impairment that he or she sees at the time that they're, questioning you, they can still arrest you on probable cause. I've seen many a video where someone's refused all tests. Does that mean that you don't get arrested because you didn't give them any, evidence to form probable cause? No. Because the officer can base his probable cause on the pattern of driving, he or she, or the speech, the bloodshot, glassy eyes. Also, they do a test which is called HGN for short, horizontal gaze nystagmus, and that's where they take a pen and they look at your pupils to see if they're dilated. And many officers will tell you, that I've spoken to at least, they think that's a very accurate test. A lot of jurisdictions, it's not admissible in court, but for purposes of probable cause for the officer, that is one thing that they can do to determine whether they feel that they have probable cause to arrest you. So, yes, they can still arrest you even though you refuse any of the tests that they request that you perform.
Now, as I understand, correct me if I'm wrong, this is just another thing I've heard from friends. Mm-hmm. Is it true that if you refuse, you automatically forfeit your license for at least a year? Is it something like that? Is that true, or is that just...
That's correct, because if everybody who has a Florida driver's license, there is what they call the implied consent on there.
Right.
So by accepting, it's a privilege to drive, it's not a right. By accepting a driver's license, you consent to the test, the breath test, the blood test, the urine test, whichever one that's requested of you. And a refusal is going to be a suspension for a minimum of 1 year. If you've refused previously on an unrelated traffic stop, then it would be 18 months. And it also could become a crime. So if you've previously refused and now you're refusing for the second time, that is a misdemeanor in and of itself. And you can be, sentenced to jail just for that. So, yes, the answer to your question is yes, you must take the breath test if you want to avoid that suspension for 1 year. But let's say you take the breath test and, it is over the 08 limit, because in Florida it's 08 at this time. I don't know if it's going to go any lower than that. There's talk about that, but right now it's 08. So let's say you blow a .10. That's a 6-month revocation. So it is it is less. I mean, still a revocation, but it's a lot less than the 1 year. Now, people always ask me, should I blow? And that's a good question, because if you don't blow, we know that you're going to get a revocation for at least a year.
Is that even if you request a blood test?
They don't have to give you a blood test.
Really?
Right. So the law says they have to offer you the breath test. If it's impractical to give you a breath test, let's say in cases where you've been hospitalized because there was an accident, and it's impractical to do the breath test, meaning that they just don't have the means to do it. Then they can ask for a blood test at that point. And if you refuse the blood test, then that's a refusal on your part.
Now, isn't there a lot of questions about the reliability of these breath tests? I heard, I think it was Sarasota had to throw out a whole bunch of cases where they said that the equipment wasn't properly calibrated.
That's true. I mean, you can actually go online, and let's say you've been arrested for DUI, and the machine that was utilized in your breath test, you want to know, was that machine calibrated recently? Was it inoperable and went out for service at some point? You can actually check the maintenance online of that machine. You can go to FDLE on their website if you have the police report and you have the number of the toxilizer machine that was utilized. You can actually go online and check the history of that machine.
Really?
Yeah, you can do that. And yes, in some jurisdictions, it has been thrown out. In essence, it's not admissible in court. Can they use it as probable cause to arrest you? I mean, yeah. But again, we're talking about admissibility in court. In this circuit, though, the Sixth Circuit, which is where we are right now, Pasco, Pinellas County, the courts have found that breath test is admissible.
Okay.
But again, if you want to get an expert and challenge the validity of it, you certainly can. But again, we're talking about a lot of money that people would expend to defend themselves.
Right.
A lot of clients that I have, they don't have that kind of money. I've had some that have, and we've utilized experts. But, the general person does not have the kind of money to challenge the machine and so forth.
Okay. We're talking to C.C. Condi from the law firm of Lucas Green and Magazine. You can call them toll-free 1-800-446-5879. And in the studio, you can call us 866-826-1340. Now, I had a friend, he got popped for a DUI doing something stupid, obviously, and at a party, he brought out this DVD that had his entire arrest from the point where he was arrested to the point where he was interrogated. Are the police required to videotape the entire DUI investigation or not?
No, they're not. There's no requirement that they have to by law. Most agencies will, because a lot of times the video helps the police and the prosecution of the case, to be honest with you. But no, they're not required to videotape. I know some clients come in and say, oh, they didn't videotape, it's got to be thrown out. But that's not the state of the law, so no. But a lot of agencies do videotape.
Okay. And now what if I'm found not guilty of DUI? Will the Department of Motor Vehicles lift my license suspension?
No. If you're the court, it's interesting because the court has jurisdiction over your license when you get a DUI, and so does DMV. And they may not do the same thing. So each individually can do whatever, the law prescribes to your license, and one is not affected by the other. Sometimes it is. So let's say, and I have clients where we challenge the suspension from the DMV. We went to the formal review hearing, and the DMV said the formal review hearing officer agreed with us in our legal argument and threw out that suspension. So now my client is able to have his or her license back, and our court case, however, has been continued for whatever reason, and we're still going to court. We're still fighting that DUI. My client chooses to go to trial on the DUI, and my client gets convicted now. Now the court can impose a 6-month revocation, and my client now is with a revocation from the court, even though DMV threw out the revocation. And vice versa. Let's say DMV, you end up, you lose your formal review or you accept the suspension, then you go to court and your DUI gets thrown out. Then you say, well, why is my DMV suspension still in effect if my DUI was thrown out? Again, they're two separate procedures and two separate entities that control your license. So,
interesting.
Yeah, it's confusing for most people. When most people come in to see me, first of all, they're overwhelmed.
Yeah, I can imagine.
Because of the immediate suspension of their license. Their car was seized. They were in jail for 8 hours. They had to post a bond. They're booking photos online. I mean, it's very overwhelming when someone's charged with a DUI and they really don't know what to do next. And it's important to hire a lawyer right away so that you know your legal rights, first of all, that affect your license immediately. And then when you go to the court, you need proper sound legal advice, because a lot of these cases can be plea bargained down, to a lesser charge, that you don't have to get a DUI conviction just because you're arrested.
Right.
So it's important to have a lawyer, though, to negotiate that, to look at the case, look at the evidence, and negotiate maybe a lesser charge of reckless driving or careless driving on your behalf.
Okay. Now, I don't know if you can tell us this, but what do you usually see? Is it usually somebody who had a couple drinks with dinner and then got in their car on the drive home and got popped, or do you see a lot of people who went to the bar and really tied one on and then got caught?
I have to say, I see everything.
Right.
I'm trying to think of what I see the most of. I get a lot of people that have had drinks with dinner. They may have gone to happy hour with coworkers after work, had a little too many drinks, and got in an accident. And unfortunately, especially here in Pinellas County, the roads are saturated and there's accidents constantly.
You're not
so you
kidding.
may not have even caused the accident, but once the police get there and they smell that alcohol
Yep.
on you, you're probably going to get that DUI. And that's how a lot of the cases come in, is because they've been in an accident and they got cited for DUI.
So, okay, well, we're on that topic. If I'm in a car accident, whether I caused it or not, and I have insurance, will I be required to pay restitution to the person in the other car?
If you are convicted of DUI,
Okay.
yes, you can be required by law to pay restitution. Most people have car insurance, so if your car insurance has covered the restitution for the person you hit, or the person that was involved in the accident, then that would satisfy your requirement in the criminal case to pay restitution if you're convicted of DUI, of course, or you plead guilty. If your insurance maybe only covered, like I had a case recently where the insurance only covered maybe $10,000 of a $30,000 restitution claim, then the state can make as a part of the restitution order the remainder of that amount owed. So then my client would end up with the $20,000 remainder of the restitution as part of probation. So yes, you can be required to pay it even though you have insurance. Maybe insurance didn't pay it all. Depends on the amount of the damage that was caused by the accident.
And then what sort of penalties can you face if you're unable to pay the remainder of the restitution?
Well, you would violate probation. If you were charged with a misdemeanor DUI, then the jurisdiction of the court is 1 year for probation. And you would have to, satisfy that part of your probation in order to successfully terminate it. If you had no insurance at the time of the accident, then most likely the Department of Motor Vehicles is going to enter what's called a financial responsibility suspension on your license. So what they do is, let's say the amount of the damage that you caused was $25,000, and you don't have $25,000. What they do is they place that $25,000 restitution suspension against your license, and the only way to satisfy it is to either pay that amount or get the victim, the person that you hit, to sign some kind of release of liability. So that's the consequence of not having insurance when you're in an accident.
Yeah.
It's a very big one, because a lot of people, cannot satisfy it if it's a lot of money, and they end up driving with no license and then getting more charges, and it kind of gets out of control at that point.
It's especially amazing considering how many people you hear are driving around right now without insurance.
There's a lot of people driving with no insurance.
I've been hit by someone without insurance, so
True.
Yeah.
And then, again, some of them don't even have a license,
Exactly.
so they don't care anyway.
Exactly. Our guest today is CeCe Conde. She is an expert in DUI law, and you can call us in the studio and ask a question. It doesn't necessarily have to be about DUIs. She's said she'll take other questions as well. 727-441-3000 or 1-866-826-1340. And if you'd like to contact her off the air through the law firm of Lucas Green and Magazine, there's an 800 number 446, 5879, and we also have a local number here, 727-849-5353. And also, you can contact her through email, cc@lgmlawgroup.com. So, while we're on the subject of the penalties here, how long will the license be revoked if you get convicted of a DUI?
Well, if it's your first DUI, the revocation period is 6 months. If you have, subsequent DUIs, it all depends on the time frame. If you have a second DUI within a 5-year period of the first conviction, then you're looking at a 5-year revocation. If you've got 3 within 10 years, not only can you then be charged with a felony, but then you're looking at a 10-year revocation. Of course, any fourth DUI is a lifetime revocation, unfortunately. Even if your priors, I had a case recently this week where the gentleman's priors were out of state, but he had at least 3 prior DUIs. The last one was 01. Unfortunately, a lifetime revocation was the consequence in his case. So.
And is that like that in every state or just in Florida?
It depends on the state. I think most states, though, if you've got, 4 DUI, probably going to take your license forever. Now, however, forever doesn't mean forever.
Right.
It depends on, you can go for like a period, I think, of possibly 10 years and maybe able to apply for a hardship license. Sometimes that changes, with the DMV. I know that at one point you could and one point you couldn't. So really the law changes as to whether a permanent revocation is really a permanent revocation. So.
Okay. Now, what is a formal review?
Well, the formal review we talked about, the formal review is when you get charged with DUI and you have your license is suspended for either refusal or an unlawful blood alcohol level. Again, that's anything over 0.08. You can challenge that suspension by filing what's called a formal review with the Department of Motor Vehicles. And you have to file that within 10 days of the date of the citation. And the formal review really, they only address very narrow legal issues. It's not guilt or innocence, whether you're guilty of DUI or not. It only addresses a few things, whether the officer had probable cause to stop you. Of course, if you're in a car accident, probable cause is there to stop you because you're already in the accident. So, and the other is, was there probable cause for the officer to believe that you were under the influence of alcohol or drugs? And normally the officer, will testify or it will be in his report what the clues of impairment were. So usually that's not difficult for that to be shown to the hearing officer. And the last legal issue is if you've refused the breath test, the issue becomes whether you were read implied consent, because you must be read implied consent if you refuse. Implied consent is what we talked about. That's the warning.
Right.
The warning that says if you refuse to take the breath test, blood or urine, then your license will be suspended for a period of 1 year on a first-time refusal, up to 18 months on a second. So if the officer did not read you that, and it's shown to the hearing officer that that was not done, then you can have the suspension thrown out from the DMV. But again, that's the purpose of the formal review hearing.
Okay. Now, is there any benefit to waiving the formal review if it's your first DUI?
Well, like I said, the new procedure, it allows people to have a hardship license right away. So with the formal review, you can certainly file for the formal review. You can get that little temporary hardship. However, if you lose your formal review, there's what they call hard time, in which you cannot get a license for a period of time. If you had an unlawful blood alcohol level and you have a 6-month revocation and you lose that formal review hearing, you've got 30 days hard time, no license. If you refused, 90 days hard time, no license. So the benefit, I think, if it's your first DUI, again, you have to be eligible to get this immediate hardship. The benefit is there's no hard time. So you don't stop driving for any period of time.
Okay.
There's no risk there.
Okay. Now, under what circumstance would I be required to have an ignition lock?
ignition interlock.
Yeah.
Any second DUI. So if you go to court and it's any second DUI, you're going to have an interlock put on your car before you be eligible for a license if you're convicted of that second DUI.
Okay.
Even if it's a first and your breath test, let's say, was over a .15, if you're convicted of DUI, you have to have an interlock put on your car for 6 months in order for you to get a hardship license or your regular license. So you have to have interlock for 6 months on a first-time DUI if it's over a .15 blow. Or let's say blood draw. If your blood draw is over a 1.5 as well.
Okay, now can the DMV require the interlock even if the judge doesn't order it?
Yes, they can. And I've seen that happen, unfortunately, for people.
All right, now
yeah.
This may be a silly question, but what happens if you're caught bypassing the interlock device? I suppose that would have its own special charges.
Well, yeah. I mean, if you've gotten your hardship license and you have when you get an interlock device put in your car, it becomes a restriction on your license. So clients ask me, well, why can't I just drive my sister's car? You know, because if you get stopped and they see the restriction on your license, they're like, there's no interlock in this car. Then you're going
in trouble.
Well, you're going to lose your hardship. Number one. And number two, you could be charged with violating the hardship. It's a violation of your hardship license, which is a criminal penalty as well.
Well, I'd heard stories about drunk people getting in the car and having someone else blow into the device for them, which just seems insane, but hey, it's a crazy world.
Yes, I don't know. I can tell you that the interlock is very expensive. It costs several $100s just to get it installed.
Right.
And then there is a fee monthly that you have to pay to maintain it.
Wow.
So it's very, very expensive. So getting back to the issue whether I should blow or not, let's say, if you feel that you're going to blow over a 1.5, probably be better not to blow because of the enhanced penalties involved.
Right.
And the enhanced penalty would be on a first-time DUI, double fine. So, in essence, first-time DUI is $500 fine. Becomes $1,000 if you blow anything over a .15. And the interlock must be placed in your vehicle as well for 6 months at your expense. That's another, penalty for blowing that high on the breath test.
Okay. Now, what is a pre-trial diversion program, and can I get one if I got a DUI?
A pretrial diversion program is for first-time offenders, and you can qualify if you've never done the diversion program previously, and indeed this is a first-time offense for you. Unfortunately, you can't do it for traffic, and DUI, even though it's a criminal charge, is traffic. You can't do it, at least in this jurisdiction, you cannot do pretrial for a DUI. And you can't get what's called a withhold on a DUI, meaning that you have to be formally convicted of DUI if you were to plead guilty.
Okay. What about, can you get a DUI conviction off your record? I guess you'd say expunged. Is that possible?
No, and the reason why it's a conviction is so that you can't get it expunged or sealed as well.
Right.
So in order to get a record expunged, you cannot be formally adjudicated guilty of any crime. And the reason why I believe that you cannot get a withhold on a DUI is because the penalties go up with prior DUIs. And if you were able to get, DUIs expunged, then, subsequent penalty wouldn't be as great because they would know about it. So, unfortunately, once a DUI is on your record, it stays there. And I've had clients come in and ask me, well, don't they purge your driving record after 7 years? Won't it just go away on its own? And the answer is no. I've gotten Florida driving records with people who had DUIs like in 1978.
Wow.
And it showed up on their Florida driving record. I had one client, he had I think it was 6 or 7 priors. And mind you, a lot of them were from the late 70s and the early 80s. But he even had some from Georgia that showed up on his Florida driving record.
Wow.
Yep. So, and unfortunately also, even if it doesn't show up on the driving record, state attorneys will get a what they call an arrest record for each person charged. And the arrest record is an arrest anywhere in the country. And a lot of times they will see on your arrest record that you have an arrest for DUI in New Hampshire, let's say.
Mm-hmm.
That will then lead them to, pull driving records from the states where they see prior convictions.
Wow.
So, or prior arrests, I should say, not convictions.
Right.
So, unfortunately, there's ways for the state attorney to get any prior DUIs, and it does stay on your record permanently, unfortunately.
Are there any situations where the state's attorney would have trouble accessing records from another state?
Yeah, sometimes. I mean, each state's different in how quickly they get the record to the state attorney. There is such a thing in everybody's case called speedy trial. Especially in misdemeanors, there's a 90-day window there if you don't waive speedy trial as a defendant. And if they want to prove the priors, then they have to act swiftly in getting that prior record. But it just depends on the state that they're seeking the records from. I've had cases where they tried and they couldn't get the records for whatever reason, so then they would agree to not count. Let's say they saw the priors on the arrest sheet. The arrest sheet isn't proof of a DUI, though, so they really can't use that. And if they can't get the record, sometimes they'll just offer you, okay, we're going to treat this as a first. And they're not going to count anything they see on that rap sheet as a prior record. Because basically they can't legally.
Wow. All right, so let's assume that I am granted a hardship license. Where am I allowed to drive? Where am I not allowed to drive?
Well, this question comes up all the time with clients because they're very concerned about following the law, especially first-time offenders who've never been in trouble ever in their lives.
Mm-hmm.
And they want to know, what does the hardship mean? Can I go to the grocery store? Can I go to church? And the statute is that you can go anywhere that you need to conduct the normal course of your daily business in your life.
Not to the bar.
But you can't go to the bar. You can't give people rides somewhere. You can't go eating at Applebee's and bring your friends. Basically, you have to carry on just very basic functions.
Right.
Go to the doctor, go to work, go to the grocery store, go to church, go home. That's pretty much it. If you're driving around at midnight, and people do on a hardship, unfortunately,
right.
And I've had clients charged with this, the officer will be behind you and he'll run your tag or she'll run the tag and find out, oh, this person has a restricted license. I'm going to stop them because this is midnight now, and who's working at midnight?
Right.
And that's oftentimes how they, get charged with, violating their restricted license and then lose it.
And I would assume you don't get let off with a warning for that.
No, and they'll arrest you too, and they'll impound your vehicle, and it's a bad situation overall. So I always tell clients, I go, just don't be driving around at these odd hours, coming back from your girlfriend's house or your friend's house, and you should be okay. But it's kind of a gray area, to be honest with you, exactly what is required. What is necessary for you to drive.
Wow.
But I think, you won't have a problem if it's, basically to, like I had one client, she had to pick up children somewhere in another jurisdiction. And certainly, she would be able to do that for a visitation.
Okay. So would you call someone ahead of time first and check and see if it's okay, or you just do it and hope that it is?
No, there's no one to call ahead of time. There's no one to call. I mean, it's really a judgment call on the person's part.
Okay.
I have clients email me, and I need to go here, I need to go there, and I'll respond to them quickly and say it's okay. You can go, pick up something in Hillsborough for your boss. So there's no restriction that you can't leave the county in which you reside.
Okay.
But some people think that you have to be confined to the county in which you live, but that's not true.
Okay. We're talking to CC Condi with Lucas Green and Magazine, and she's teaching me a whole lot of stuff that I did not know. I hope you're gaining from this as well. If you want to call her off the air, you can call 1-800-446-5879, or check out the website lgmlawgroup.com. And if you want, we still have a little time left. You can call us in the studio 727-441-3000 or 1-866 826-1340. Don't be shy. How about if I get a DUI, do they have to impound my vehicle? Is that mandatory?
Well, it's not mandatory. I mean, if there is another licensed driver who has authorization to take the car, who's not impaired, obviously, then the police can allow that person to remove the vehicle. Yeah. But, they don't have to wait for you to call someone to show up to take the car. So the police aren't required to wait for someone to get the car. They can impound your vehicle at that point.
I would have figured that it would be considered a crime scene. No? No,
it's not really a crime scene. The crime is not the car. The crime is the person driving the car under the influence. If it's an accident case, if the car is immobile, I mean, it can't be driven, then obviously it would have to be towed, and it would be towed to an impound yard, and then you have to pay to get the car out of the impound yard, which is very expensive.
Okay, so it's been said that in some states they'll purge your driving record after so many years. I think we already covered that, but Florida does not do that.
No, Florida, nope. Like I said, I had one client in a DUI from like 1979, unfortunately. So they do not purge the driving record. It's going to be on there.
Okay, now this is a big one.
Okay.
Under what circumstances does a DUI become a felony?
Well, as I said before, if you are driving and you are presumably under the influence and you get in a car accident and you cause great bodily harm, that can then become a felony. And what is great bodily harm? Great bodily harm is if someone has a serious injury or a permanent disfigurement. So if you run into another car and the person ends up with maybe brain damage, even broken bones, that could be considered serious bodily harm. And then what seemingly is a DUI, if it's a first-time offense, would be a misdemeanor, becomes a third-degree felony at that point. Okay? If person dies, obviously that's a DUI manslaughter.
Right.
If you have, this is your third DUI within a 10-year period, that can now be a felony. And all three of them don't have to be within 10 years of each other, the convictions. Only two do. So if you have, this is your third DUI, you have one within 5 years and you have the other one outside of the 10-year window, that still could be considered a felony.
Okay.
And any fourth DUI can be considered a felony.
Okay. Now, my dad has a CDL, and he always told me, if I'm over a .0405, I'm in big trouble. How does a DUI affect somebody with a CDL?
Well, a CDL, when you accept the CDL, if you refuse, you're going to lose your CDL for a year. No hardship.
Okay.
So, for most commercial truck drivers, they're going to put them out of business.
Right.
And if you blow over a .04, you're going to lose your license for a year, and you're not going to get a hardship. So it's pretty serious for CDL drivers in a commercial vehicle to get a DUI because of that penalty. They lose their job, they lose their livelihood. And unfortunately, I've had CDL truck drivers that refused and ended up with a year's suspension, and they couldn't work. So it can be very serious for people that hold a CDL.
Is there a situation where it can be permanently revoked, the CDL?
I think if you have, if you have more than one DUI.
Okay.
Yeah.
Well, that makes sense.
Yeah, if you have any kind of very serious offense where someone is permanently disfigured or killed, of course, yeah.
Okay. Can I be charged with multiple counts of DUI if I'm involved in an accident?
Yes, and oftentimes you will see multiple citations from one accident. And the law says that the officer can write you a ticket for DUI for driving. He can write you, or she can write you, a ticket for injury to another person. That could be another citation if there's somebody in the other car that you hit. So now you have a DUI with personal injury. And also for the property damage you caused. So now you have a DUI with property damage. And most people say, well, wait a second. I was just driving and I hit someone. It was one incident. Why do I have 3 DUIs from one incident? Because they can write it that way. Because you have, someone that's hurt and you have property that's damaged. 3 citations for 1 incident. Now, oftentimes, nobody really gets convicted for 3 at one time. What happens when you go to court and you resolve the case, the state attorney will they will merge and dismiss 2 of those DUIs so that you only have 1. But that takes place in the court system when you resolve your case.
Okay.
But it's very confusing because, people wonder, why am I getting so many citations for 1 incident? Well, the law says that they can write that many citations.
Wow.
Yeah. Plus, they can write you a citation for careless driving. I mean, they can write you a whole litany of civil infractions. I mean, I've had clients from 1 accident get like 7 tickets for not wearing a seatbelt, for not staying within their lane. Maybe they got a careless driving, they got a speeding, whatever the officer, equipment violation, no proof of insurance.
Well, you'd almost think that those would fall under the DUI because if a person's driving drunk, then what's the point of putting a seatbelt on?
That's true. However, a lot of judges that you go before, and I practice in Hernando, I practice in Hillsborough County, Pasco, and Pinellas County.
Okay.
And sometimes I go down to Manatee, but not too much. It depends on the judge that you're before. I mean, a lot of judges take the stance that they cannot merge and dismiss those infractions with the DUI, even though, you'd think that's kind of as part of the DUI. And there's some judges that will do it as a matter of course. They'll merge and dismiss all infractions. So it just depends upon the actual judge that you go before.
So is it a tendency for them to merge and only count the one that's the most severe charge, or
in terms of the DUI?
Yeah.
No, oftentimes the state attorney will make the decision about which one they'll proceed on.
Okay.
And it's just a matter of case numbers. It doesn't. There's no severity of one opposed to the other when you've got 3 citations for the same incident.
Okay.
They'll just pick whichever one to proceed on and merge and dismiss the other 2.
Okay. Can it be reduced to a lesser charge, such as reckless driving?
Yes, and actually that's what a lot of people want, because if you have a reckless driving, it does not trigger the same sanctions and the insurance repercussions as a DUI. So, in essence, a reckless driving, there's no mandatory suspension of your license. You do not have to get that insurance that requires you to carry a much higher amount of liability than anybody else. You don't need that on a reckless driving.
Okay.
And the fine is not as high and so forth. So it is really something that a lot of people come in and want, but the state attorney, they kind of pick and choose which ones they're going to allow to plead to reckless driving based on the facts of the case, the person's driving history. So there's a lot of factors that go into whether the state attorney will reduce the case to a reckless driving. It's not simple.
Okay, what is an enhanced penalty?
Well, the enhanced penalty we talked about is the double fine. It's the ignition interlock. And again, that has to do with the breath test. So if your breath test right now is over .15, then you are going to end up, if you're convicted of DUI or plead guilty, you are going to end up with an enhanced penalty. That's tough because it's very expensive. A DUI is expensive to begin with.
Right.
But to have to get that extra fine and that enhanced penalty of the ignition interlock really, really skyrockets the amount of money that you're going to have to pay out of pocket.
Okay. And should I have an attorney represent me if I'm charged with a DUI, or is this something where you ever see people try to go it alone?
Most people do not try to go it alone on DUI, and that's because it is very confusing to them. They don't know all of the ins and the outs of how to get through this, the quickest way and the most, I don't want to say cheap way because really
right.
There is no cheap way out of a DUI.
Right.
There's no cheap way out of a DUI. But you really should have an attorney look into all of the legal issues for you, negotiate the case for you. It really is foolish to go to court without a lawyer on a DUI because of the permanency of a DUI, as we talked about, and the repercussions on your insurance, maybe your job. It really is foolish to have a DUI, not have a lawyer handle those legal issues for you.
Yeah, I can't imagine. I'm sure somebody's tried it. I mean, I suppose you have the right to represent yourself. Somebody's probably tried it.
I'm sure. I think most people that I see going into court, they have a lawyer. And if they can't afford a lawyer, the public defender can be appointed to their case and can assist them in negotiating through, a DUI. But the one thing, the distinction between getting a private lawyer and a public defender is the formal review aspect. Public defenders are only appointed to handle the criminal aspect of your case.
Right.
They do not handle the formal review. They don't handle DMV issues. So that's why a lot of people that come in to see me, they want a lawyer right away because they have this 10 days to do something.
Exactly.
And they want to know, what do I do? How do I do it? Some people try to do it on their own, but they don't really understand the legal issues involved. So that's why, again, it's very important for somebody to get a lawyer right away. At least consult with a lawyer and find out, what should I do?
So they'd want to call someone like you, and they can do that at 1-800-446-5879. And I would call you. I don't plan on getting any DUIs, but it's possible. I've heard, mouthwash or toothpaste or something sets off the... Then I would call you.
Anybody can get a DUI. Anybody. I've had clients that were 85 years old, coming back from the VFW, having a couple of beers with their buddies, and they get a DUI. DUI doesn't discriminate. Anybody can get a DUI. I've had doctors. I've had nurses. I've represented all walks of life on a DUI. So it's the type of crime that anybody can get. I've had teenagers come in with a DUI. And
there are things that can trigger the machine, right? I mean, there's cough syrup or mouthwash or things like that.
Yeah.
If you just...
That's true.
I mean, I meant to ask this earlier.
Sure.
If you had a beer, for example, 5 minutes ago, it's going to show up pretty strong on that breathalyzer.
Yeah, and shots.
Right.
Unfortunately.
Right, because it's still fresh on the breath.
Right. If you're diabetic, that can also throw off the machine.
Right.
And we're seeing a lot of people with diabetes, so that could throw off the machine. If you wear dentures, that can throw off the machine because of the porous nature of the dentures can hold the alcohol.
Right.
Because we're talking about breath alcohol.
Right.
If you regurgitate it all or spit up in your throat during that 20-minute, they have to observe you for 20 minutes.
Yep.
And you do that can throw off the machine too.
I'd imagine it could spike it considerably.
It absolutely could, because imagine if if you've ingested the alcohol, now some of it's now come up, it's going to affect that breath test as well. And again, these are things that you need a lawyer to look at. You might be able to negotiate with the state attorney and say, hey, this test is flawed.
Right.
I mean, look at what happened here. Look at the observation period. The officer wasn't even looking at the person. How could he observe whether he spit up in his throat or what? Whatever the issue is. You need a lawyer to negotiate those things for you, and you really should have good legal counsel.
Well, Cece, thank you so much for coming in. Cece Conde with Lucas Green and Magazine. Again, 1-800-446-5879. Or also 727-849-5353. You can email her at ccc@lgmlawgroup.com. And before we sign off today, is there anything else that you can share, the most important thing that you think you can share with our listeners?
Well, I always tell people, have a designated driver. Of course, maybe I'd be out of a job, but it's better to be safe out there on the roads.
Well, in this state, I doubt that you'd be out of a job.
Well, that's true. I mean, it is Friday and happy hour.
Exactly.
Yeah. So
you might be getting some calls soon.
I always do every weekend. So
again, the number is 1-800-446-5879. Cece Conde, you've been great. Thank you so much for coming in.
Thank you.
All right, it's 4:01 here at Tampa Bay's Tan Talk Radio Network. Running a little over there. I wanted to get all those questions in. Catch us next week on the Legal Forum at 3 p.m. here on Tampa Bay's Tan Talk Radio Network. Again, we had Cece Conde in. If you have questions, you can ask her those off the air. cc@lgmlawgroup.com or 1-800-446-5879. Tom O'Brien and the Tiger Financial News Network coming up right next, right here after traffic and weather. Don't touch that dial. You're listening to Tampa Bay's Tan Talk Radio Network.